Ali and another partner.
Yes.
My lords, my lady. If I remember rightly, where we had got to yesterday afternoon was that the court had just read paragraph 26 of Baroness Hale's speech in Essop.
Yes.
So I wanted to return to that.
You haven't. That's 30. Yes, you haven't. Nobody so far has raised the fact that the appeal in Essop was from me. But anyway, we did have at least somebody else who knew something about the subject.
Perhaps it would be helpful if I just briefly set out the scheme of what I intend to do with the remainder of my time.
Yes, thank you.
I'll briefly conclude on ground 3. Ground 7 is, of course, not pursued any longer. In relation to grounds 4 and ground 6, I propose essentially to rely upon my written submissions, because I say that those grounds of appeal are non-starters in the case of
grounds 4 and 6.
4 and 6.
Yeah, you rely on your skeleton.
As a general point as well, in light of the time,
Yes.
I would say that I stand by my skeleton argument. So
Yes.
if for any reason a particular point doesn't emerge orderly, I'm not dropping it. So after I finish ground 3, I intend to focus on ground 5, and in particular the section 23 issue and the reasons why it's wrong to exclude women on maternity leave from the pool.
Yes.
So going back to ground 3, I say that there's no evidence anywhere in the AT's judgment that Mrs. Justice Slade failed to apply this test of causation. That is the ground of appeal in ground 3. She even quotes from paragraph 26 in her judgment at paragraph 34. The test is of but for causation. The PCP is a but for cause of the disadvantage, and equally, as she says in paragraph 26, the context factor is a but for cause.
Oh, can I ask this? What are we looking for here in the but for causation? Are we saying that if the PCP did not exist, then the disadvantage, there would no longer be a disadvantage? Is that what we're looking for in every case? In general, not just this case, but generally. So a PCP is there. The cause that you have to show that the PCP has caused a disadvantage. You say it's a but-for test. So what are we saying? Are we saying but for, in other words, if that disadvantage wasn't there, then, if that PCP wasn't there, then things would be better. Now, you can see that's easy enough when you say something which is a qualification for something better. So, or a qualification for a job, for example, or something like that. So if you say, well, you have to be 5'6" to get into the police force. Well, the disadvantage you can see is that women, as opposed to men, generally speaking, are not as tall. Therefore, if you removed it, it would plainly make it easier for them to get into the police force. That doesn't really work with this PCP, does it? Because if you remove the PCP, in other words, the right to receive statutory pay, the statutory rate, if you want to take share parental leave, wouldn't improve your position. You have to go on and say something else. You have to say, if it was removed and you got something more than that, which somebody else happens to be getting. So I'm slightly troubled by the analysis of the causation argument.
Well, the answer lies in paragraph 26, I say, my lord, in that
26 is what?
Either or the PCP or the context factor may be a but-for cause of the disadvantage. And in this case, I say...
You're in 26 of Aesop.
Yes. And in this case, the PCP is a but-for cause of the disadvantage. The disadvantage is there are two stages to the disadvantage. There is identifying the disadvantage to the male group and then comparing the extent of that disadvantage with the extent of the disadvantage for the female group. So in the first instance, in terms of the male disadvantage, it is, as I have already described, the difficulty of the choice as to whether or not to take the leave in the first place, or if somebody does choose to take the leave, the ensuing difficulties arising out of receiving significantly less pay. So in the first instance, I fail to see how the PCP can be anything other than a but-for cause of that disadvantage, because self-evidently
It stops them getting more, but they wouldn't otherwise be entitled to more. And in other words, there's not something that's there that they would otherwise have a right to. That's what I'm trying to drive at. In a case where you have a PCP and but for the PCP, you would have a right to something else, or you would have there's something there that you could go for, an opportunity, a payment, whatever it may be. I can see it, but that's not this case. You have to say, okay, if the PCP wasn't there, I would be entitled to get something more, and I should get what the women are getting, maternity. But what other case is there that's comparable to that?
Well, the answer is, my lord, that the causation doesn't have to be both the PCP and the context factor. It can be one or the other. So in this case, if we assume your analysis is right for the moment, that doesn't change the fact that when we get to the comparative stage of the assessment of the disadvantage, the cause of that is the availability to women of full pay or maternity leave. That, if we go back to paragraph 26, what Baroness Hale says is of context factors, that they can be many or various. She says at the bottom of the page, they could be another PCP working in combination with the one at issue, as in Chief Constable of West Yorkshire Police and Home. So in this case,
Yes, but sorry, you have to carry on there. Where the requirement of a law degree operate in combination with normal retirement age. That's the point. There's something else that's there that you would otherwise be entitled to. But that example doesn't help you.
Well, that's the context factor. The two things work in tandem, I'd say, and only one or other has to be a but-for cause. In some cases, both will be a but-for cause, but only one.
But the context factor is always going to be a cause. I don't know, where do you get this that that the PCP doesn't have to be a but-for cause for the disadvantage? I think the whole structure is that it does.
Well, because there are the two stages to the assessment of the disadvantage: the initial disadvantage in isolation, and then the comparative. The Section 19 requirement is to analyse the comparative disadvantage, and looked at in that way, what you have to do is compare the male position with the female position, and the context factor here is what the female.
That's a separate, right there. You've got to very, very. I would suggest that you have to be very careful in your analysis and in breaking down each section. The first one is you identify your PCP. The second one is, having identified your PCP, I would suggest at that point, probably logically, you have to say why that PCP is a cause of a disadvantage. The next stage is to identify the pool of people who are subject to the PCP. The next stage is to identify another group sufficiently similar to be able to make a comparison, and having made that comparison, to draw the conclusion that that one group suffers a particular disadvantage. I would suggest that is probably, you might be able to put the causation after the pool, but it doesn't matter. It comes before. The point is that the causation is something that has to be established before you get to the question of saying, is that disadvantage suffered in particular, to a particular degree, by this group as opposed to another? Now, yours kind of mixing in together those two stages.
I disagree, my lord. I I go back to the words of section 19, subsection 2,
Hang on.
paragraph B.
One moment, let's have a look. Section 90. 90, yes.
Paragraph, subsection 2, paragraph B, the PCP puts or would put persons with whom B shares the characteristic at a particular disadvantage when compared with persons with whom B does not share it.
Yes.
So the nature of the exercise is we're seeking to establish a comparative disadvantage,
Yes.
and the PCP must cause comparative disadvantage.
Well, no, because in the instance that my Lord Master of the Rolls gives, where you have a height requirement, it's not the height requirement that causes women to be disadvantaged, it's the fact that women tend to be shorter than men.
Yes.
So it's not the PCP that causes the disadvantage, it's the fact that women tend to be shorter that causes them to be less able to comply with the PCP.
The context factor, yes.
Well, what is the context factor in that scenario?
As you describe, my lady, the fact that a higher proportion of women will be unable to because women tend to be short. I wouldn't like to say by way of assumption that is necessarily a true fact, but for the purposes of the argument, if we assume that women tend to be shorter than men,
Let's assume that.
then that is the context factor.
So the context factor in your analysis is the difference between men and women, which makes them one group less able to meet the PCP.
Yes. And in this
So
case,
what is the context factor? How would you express the context factor in this case?
it is the availability to women who either do or intend to give birth of another option of maternity pay. That is, I would venture to suggest, where Baroness Hale refers to the PCP potentially, the context factor potentially being another PCP. In this case, that would not, strictly speaking, be a PCP, a second PCP in its own right, because it only applies to women. It doesn't apply to everyone. But I would characterise it as a quasi-PCP. It is something that's available to women that is not available to men, and is the reason why women don't suffer the same disadvantage of the men as in terms of the difficulty in choice.
The trouble is, the problem I have with this analysis, I take about a section 9, I think section 19.1.2b simply helps us, may help us to identify at what point you have to identify the disadvantage. So I can see that this would mean that you might push back the identification of the disadvantage from before, as it were, you see who's in the pool, to once you've both chosen the pool and you've identified a comparable group. I can see that. I don't have a problem particularly with that. The point still remains, if you're going to do it this way, the point still remains that you have to say what would have been the position without the PCP. But if you're going to do it this way, I need to go back a stage. Now, your position as the trouble is the way you've structured your grounds of appeal doesn't quite fit into the analysis as I've been mentioning. You say that the pool comprises everyone who is potentially affected by the PCP. Yes, all right. For myself, I don't have, at the moment, a particular problem with that, but others may do. The next thing you have to do then, if you take your approach, the next thing you have to do is you have to identify another group with whom you share another group with whom you share the PCP, and then you have to apply presumably section 23 because you have to make a comparison. You have to have a comparison of cases. There must be no material difference in the circumstances relating to each case.
Well, there are a number of things to say in relation to that. The other group, as you refer to, my lord, is simply the female group. So you have the pool, and you refer back to what the protected characteristic is that's at issue, which is gender, and you compare the position for the male group within the pool with the position for the female group within the pool.
Yes.
So that's the approach.
Yes.
In due course, I'll come on to my submissions about section 23, which in a nutshell are that, as Lord Justice Underhill says per curio in the Court of Appeal judgment in Naive, it's not a freestanding element of the test for discrimination. It simply reflects the cause of action that you're dealing with.
Well, all right, but I mean, you've got. If it wasn't there, you'd still have to have a group which is sufficiently comparable to make the comparison. That's what you're saying.
Well, you take the pool,
You've got the pool.
and you divide the pool into the male group and the female
Yeah.
group. And the male group, I say, is disadvantaged for the reason that I've described. And then one has to look at the female group and see the extent to which they are disadvantaged in the same way. And
But what is the disadvantage to the men?
The disadvantage to the men, as I've previously described, is the difficulty of the choice they have in deciding whether or not to take the leave in a prospective, from a prospective viewpoint. In respect of a man who does go ahead and choose to take the leave, he has to deal with the financial consequences flowing from taking the pay cut. So either way, there is a disadvantage. There is EAT case law to the effect that there is no particular threshold of disadvantage that has to be overcome. That's the case of Pendleton. I believe it's paragraph 31 where...
All right, but don't get off track. So the disadvantage is still the cut in pay he takes compared to staying at work and continuing to earn his
Yes, and
salary.
the consequences flowing from that.
Yes.
But you've now got to find a comparable. Now you've got to find a comparable group to compare.
Well, the female group,
Why? The female group comprises people, for the most part, who are or may wish to become mothers. They are there. The real question seems to me to be: are they, for the purpose of working out whether there's a disadvantage, are they a comparable group? And what's said, cutting away from all the complexity of the analysis, what is said is they're not a comparable group because they are entitled to maternity leave and pay for 5 out of 6, for various reasons up to 6. 5 of them have nothing to do whatever with looking after a child. And therefore the real critical question I'm putting to you, I'm suggesting to you, the real critical question in this case is, are they a sufficiently comparable group when the reason they get maternity leave has only 1/6 of the points, as it were, has to do with looking after a child. That seems to me at the end of the day the real issue.
yes, and I say absolutely they must be included within the pool.
That's a different point, sorry,
Well,
that's a different point.
my lord, it is not a different point because the pool flows logically from the PCP.
Yes, everybody who's potentially affected by the PCP goes into the pool. That's a different question from saying whether, when you're identifying the disadvantage that's suffered, that the women are a sufficiently comparable group within the pool. That's a different question.
Well, I say it's not a different question because, according to Baroness Hale in ESSA, in paragraphs 40 to 41, there is no warrant for excluding anyone that is affected by the PCP. So the fact that a birth mother may have chosen to take maternity leave, perhaps precisely because the rate of pay is so much more favourable than the rate of pay for shared parental leave, is nothing to the point. She is still affected by the PCP because that informs the very choice that she has made. It's a very easy choice for most women, no doubt, but she is still affected by the PCP.
So can I record as far as your submission? You're saying it is not a difficult question whether entitlement to be in the pool it's not a different question whether someone is to be placed in the pool and as to whether they form a comparable group for the purposes of disadvantage.
Yes.
Right.
So when we come to look at section 23, the question is, what are the material circumstances in a section 19 claim? It can't be right, as the tribunal said, to say, well, the material circumstances are taking shared parental leave. That is a direct discrimination analysis. If you then, via the route of section 23, impose that analysis on section 19, you just end up with section 13 analyses all the time. It would make a mockery of the existence of section 19. The analysis, the application of section 23 must be different for the purposes of section 19 in comparison with its operation for section 30. And I say, what is material in a section 19 claim is whether people are affected by or interested in the PCP, and that is all anybody needs to know.
But isn't the difficulty with your analysis that in order for a man actually to suffer the disadvantage that you envisage, namely taking the cut in pay, he must be in a position where his partner, the birth mother, has given up her maternity leave and pay entitlement. So if the pool contains women who are taking maternity leave, their male partners cannot suffer the disadvantage of only getting shared parental leave rates when they take time off. They may take time off, but it would be unpaid, and if they take too much time off, they may be fired. But the only circumstances in which a man can actually suffer the disadvantage that you say is the PCP is if his partner is also suffering exactly the same disadvantage, because she can't then have the option of having maternity leave and maternity pay.
Well, an important point to bear in mind is, of course, that we can't assume that the mother and the father will be in the same workplace. We're concerned with the PCP that applies in the specific workplace, and we're not comparing the actual father with the actual mother. We're comparing the position of men with the position of women within that workplace.
No, but what we're trying to find is who should be in the pool as affected or potentially affected by the PCP, which you've identified as the cut in pay that is suffered by somebody taking shared parental leave.
Well,
Yes.
So my point is...
But
exactly,
everyone who suffers that cut in pay, or potentially suffers that cut in pay, does so equally, because the question of them having maternity pay must now be out of the picture. Otherwise, they've no right to shared parental leave of either gender.
I don't agree, my lady. The position is that if we're considering officers going about their day contemplating what they might do in the event of needing to take leave to care for a child, the point is that the female group have two options, at least two options. They can choose to take shared parental leave, or they can choose to take maternity leave. And because, as an aside, it's not part of Mr. Hextall's case that his remedy should cover the first 2 weeks after childbirth, so we're only concerned with the period after that. But the point is that women have the choice as to what they can do, and if we exclude from the equation the more favourable option that they have available to them, then we're excluding from the analysis the very context factor that is at the heart of the analysis. Via that route, it makes a mockery of indirect discrimination, in my submission.
Well, it makes a mockery on the facts of this case, because it's a circular argument. You know, on this case, you say there's a causative link and they're a comparable group. there isn't a causative link or there isn't a comparable group, excluding them is just carrying out the rational analysis. If it's not a comparable group, and you're relying upon a disparity in benefits available to one of them, you're excluding them because it's not comparable. You can't argue from that, oh, that means you never have an indirect discrimination claim. Those are the facts of this case.
Well, it is the same in my submission as in Naeem. So in Naeem, the issue was the entitlement to pay progression, depending on length of service. And there was an issue, the difference of opinion between the Court of Appeal and the Supreme Court was that the Court of Appeal said you have to confine the pool to those chaplains, Muslim or Christian, whose employment started in 2002 onwards. Yeah. And the Supreme Court said that was fundamentally wrong. You have to include anyone that's ever been employed in that way, because if you restrict the pool to post-2002 recruits, you make a mockery of indirect discrimination because you're excluding the context factor, which in that case was that...
Well, I understand. I understand that. You're now addressing the question of who's in the pool. You can move on. I don't want to hold you up any further. My analysis was, even if you include everyone in the pool, because they're all affected potentially by the PCP, you still got to carry out a comparative analysis selecting a sufficiently comparable group.
Well, so I think perhaps, my lord, we're slightly at cross purposes. It's a question of how you formulate in words the exercise. What I would suggest is that the real question that you're positing is that whether or not women who have given birth should feature in the pool at all. Because if they're excluded, then the comparison doesn't fall away.
Right, that's not the way I'm approaching it, but you're telling me I ought to be approaching it that way.
Yes.
Yes, that's right. That's fair enough.
Mr. Leach, can I go back to something that is bothering me? The idea that a PCP for Section 19 purposes can be, as it seems to be in this case, paying men and women equally for doing the same thing or taking the same type of leave. That's the PCP. The PCP in this case is the practice of the employer paying shared parental leave to men and women at the same rate.
It's the rate of pay for shared parental leave.
Yes. Now, you know and I know that if Mr. Hextall succeeds, the next claim will be an unanswerable equal pay claim by all women at the employer, saying it is plainly unlawful on simple equal pay principles to have one shared parental leave rate for fathers and a different one for mothers who've given up maternity leave.
Yes.
The result will be that shared parental leave has to be paid in all cases at the same rate as maternity leave.
Yes.
And, well, that's a most extraordinary result, as it seems to me, when Parliament has set out in great detail different regimes for maternity leave and parental leave.
Only we have to keep in mind, my lord, the circumstances of this case, because this case is not about the regulation, the shared parental leave regulation. It's about a voluntary policy implemented by this police force. And maternity pay provisions for police officers is completely different from the maternity pay provision for ordinary civilian employees out there. The legislation that applies to police officers requires a period of full pay on maternity leave for police officers, which is not the case with regard to statutory maternity pay for everybody else.
So we are here concerned with the voluntary policy. I thought we were just said.
Yes.
But there may be other private employers who also pay more generous rates than the regulation rates.
Yes.
But what is it about the regulation rates, given that they're not compulsory and they don't preclude the employer from paying shared parental leave at the same rate as it pays maternity leave? What is it that prevents that from also being indirect discrimination?
Well, as I said yesterday, my lady, there may very well be an open question as to whether an ordinary civilian employer who is simply abiding by the minimum required by the regulations, as to whether they're applying PCP in the first place. That is quite a large and difficult question in its own right in my submission. I don't pretend to have the full answer to that here because it's not an issue in my case. It may well be an issue in another case. As I said yesterday, in a case where a small employer only ever pays the statutory minimum rate for anything, there may be an issue about whether there is any indirect discrimination at all, even if there is a PCP applied by such an employer. I take the point that statutory maternity pay rates are slightly different from statutory shared parental leave pay rates, but if it were to turn out that there is some kind of indirect discrimination in that context, it would only be to that limited extent because of 6 weeks of 90% pay versus the statutory rate for shared parental leave pay. And then there would be issues about justification in the context of a school, for instance.
So the answer to why this isn't just generally applicable is that if a company is only paying the statutory rate for maternity leave and the statutory rate for shared parental leave, there might not be a PCP, you say.
Correct.
For a small company, there might be justification of some kind.
Because what,
Yes.
to return to your point, my Lord Justice B, if in this case it is decided, as I say it should, that the policy is indirectly discriminatory in the way that the EAT is essentially identified, a simple answer might be, and this is a point I'm sure is not lost on the Chief Constable, would be the revocation of the policy until such time as the regulations are actually amended. If the policy is discriminatory, it would also follow, as night follows day, in my submission, that amendments to the regulations to the same effect would also be indirectly discriminatory, but that would have to be challenged by way of a judicial review of those regulations, it seems to me. It wouldn't be a matter of a tribunal claim. But the reason why it would be indirectly discriminatory is precisely because the regulations themselves provide for full pay, maternity pay for police officers. That is an entirely separate matter from the law that applies to everybody else out there.
Sorry, I'm trying to understand. So I've got your point about other cases with employers generally, and as I think my lady summarised, and you seem to agree, there might not be a PCP. If that employer is simply paying the statutory rates on the one hand for maternity leave and the other hand for shared parental leave, one, there might not be a PCP, and there might be justification.
And in between those points, there might be an issue about whether there is any indirect discrimination. If there is, it would be to a much more limited extent than in the circumstances of this case, because the disparity between statutory shared parental leave pay and statutory maternity pay is much smaller.
Right, but that's a different question as to how much it's discrimination. Let's just forget that for the moment. And why do you say this? Why do you say this case? You said this case is different because it involves a voluntary policy.
So
what does that mean?
Well, because here there is unquestionably a PCP that has been applied. The regulations don't apply to police officers. The force just decided to implement its policy. So, if that were not the situation, and we were talking about an employer to whom the regulations do apply, and that employer simply abides by what it's required to do. Is that applying a PCP? I say that that's an open question. That is not a matter for decision in these appeals. It may be that the answer is they don't apply a PCP by simply doing that, which would be the end of any indirect discrimination claim.
Right.
It might be that they do apply a PCP.
So you're saying the Chief Constable is not bound by the regulations that set the rate for maternity pay and shared parental leave pay,
Correct.
but it's not entirely voluntary, because I think it's accepted that the sex equality clause applies.
Sex equality clause not relevant to this.
No, but I mean generally it's not entirely in the Chief Constable's gift as to whether he decides to implement provisions which are generally implemented by the private sector.
Well, in this instance, it is. There's no requirement under the police regulations or the attendant determinations from the Home Office requiring any police force to implement this policy. They just did it. It's entirely voluntary.
So you're saying that if the Chief Constable had not implemented any shared parental leave, there would be nothing that
We wouldn't
Mr.
be,
Hextall could do about it?
we wouldn't be here.
Yes.
And it's not articulated anywhere, but it seems to be the case that the Home Secretary is waiting to decide whether or how to amend the police regulations, probably for the outcome of this litigation. And as I have suggested, I would submit that amending the regulations in a way which mimics this policy would inevitably lead to indirect discrimination, precisely because the regulations already provide for full pay for officers on maternity leave.
Now you're talking about the Police Act regulations.
Yes.
Yes.
But as I say, that it seems to me that probably wouldn't be a matter amenable to a tribunal claim. There would have to be a judicial review of the regulations if they were amended in that way.
I don't see at the moment why it makes any difference whether the employers are paying the same rate of parental leave to fathers and mothers because they are because they are typical employers governed by general legislation and under a statutory obligation to pay, or because they are police implementing a voluntary police policy. Why should it matter? On your analysis, the PCP under section 19 is paying fathers and mothers the same rate.
So in the case of the civilian employer, what I'm saying is that superimposing Mr. Hextall's claim on that factual scenario would surely be a direct challenge to the regulations themselves. You would have to be
Yes,
saying
indeed.
that the regulations are indirectly discriminatory. Is there standing effectively for a tribunal litigant to do that? I don't pretend to know the answer to that. I simply raise the issue that may well be an issue in a claim of this type if it were pursued in the private sector. It's a significant question, and it's not one that I have the answer to, but I simply make the point that that could be an issue. Probably, I would tentatively suggest that probably that type of argument ought to be the subject of some kind of judicial review of the shared parental leave regulations. I wouldn't like to say what the merits of any action of that type would be. The regulations are the regulations, and if an employer abides by them,
Right.
is that applying the PCP?
Yes.
But that's not the position in this case. to, we've kind of moved on to the section 23 issue and
Yes.
the question of whether birth mothers should be, the way I would characterise it, at least, my lord, is whether birth mothers should be excluded from the pool or not.
I don't understand why you say that, because the opening words of section 23(1) are on a comparison of cases. But when you're saying who is the CPC applicable to, when one's asking who the PCP is applicable to, you're not making the comparison is for the purpose of working out whether there's a particular disadvantage. You look at the words 19.2b. Shares the characteristic at a particular disadvantage when compared with persons. It's for that purpose that section 23 is being introduced. That's the relevance of the word comparison.
Yes, so
So it's a different exercise I'm suggesting to you. That the 23(1) is your concern with at the point at which you are making comparison in order to work out whether or not there is a particular disadvantage.
So I say that what that requires is that when you're comparing the male group with the female group
Yes.
in the pool,
Yes.
both the material circumstances have to be the same.
Yes.
And so that is, in my submission, simply another way of saying, is everyone within the pool supposed to be there? Because if you remove certain people from the pool because of an application of section 23, that affects how the comparison works out. So if you remove birth mothers from the pool, they won't be on the female side of the comparison, and you're left with a comparison which is men taking shared parental leave and women taking shared parental leave. So it's a different way of asking the same question in my submission. And fundamentally, women should not be excluded from the pool in that way, or on the alternative formulation, are in materially the same circumstances.
Why? Why are they materially the same circumstances when you're making a comparison in relation to the PCP? Because either, I would suggest to you, you're in the situation my lady mentioned to you, which is at the moment that this becomes relevant, shared parental leave, the female partner has herself ceased to receive maternity pay. She has to give up her maternity leave. Or alternatively, you're looking at a situation where women are entitled to maternity pay because of a whole variety of reasons. So why are they comparable?
Because in a section 19 case, the comparative exercise is a much broader, higher level exercise than simply comparing the specific circumstances of one man and one woman. So I would entirely accept that in a section 13 claim, the comparison is a man actually taking shared parental leave and a woman actually taking shared parental leave. That's why the discrimination claim fails. But if you, in a section 19 claim, the people in the pool aren't necessarily actually taking any leave at all. They're merely contemplating what they would do in future. Some people will have chosen to take a type of leave, but the critical question is, are the people in the pool interested in or affected by the PCP? Now I say, even a mother who has given birth and is actually taking maternity leave still has an interest in the PCP of the rate of pay for shared parental leave, precisely because she can choose to cut short her maternity leave and switch to shared parental leave. The fact that she's unlikely to do that in circumstances where she could continue receiving full pay if she chooses not to is neither here nor there. The choice is available to her. The fact that it's an easy choice is not something to be taken into account in my submission.
Yes.
So, under section 19, everyone who has an interest in that way or is affected by the PCP has to be in the pool. And more to the point, if we exclude women because they have given birth, we we exclude women because they are women, and that is an absurd proposition in my submission.
What? Sorry,
This
I
is
don't understand that. If we exclude birth mothers, we exclude them because they are women.
Yes.
What does that mean?
Well, it's a long-standing proposition of EU law, going back to Decker. Now it's contained in recital 23 to the recast Equal Treatment Directive, that doing something to a woman because of pregnancy or maternity, that thing is done to her because of sex. If we exclude women from the pool because of pregnancy or maternity, we exclude her because of sex. Mr. Basu agreed with that point in a roundabout
That's
way.
a James and Eastleigh type point, isn't it? That there's a complete congruence between the gender difference and the
in a way,
characteristics.
it's long been accepted that pregnancy, maternity and gender are indissociable. So if you exclude women because of having given birth, you exclude them because of the very protected characteristic that's in issue in the case. This is my Lockwood point. Now would perhaps be a good moment to turn to that case. My lady, my lords, you'll find that at tab 22 of the authorities file. So this was an age discrimination case dating from before the Equality Act, so it concerned particular regulations which have been superseded. But the material provision is to the same effect as section 23 under the Equality Act. There was an issue about the proper comparison. I would draw your attention first of all to paragraph 26, where the submission that was made is set out, that submission later being accepted by this court. So the error was to factor into the comparison exercise considerations that were either directly related to the claimant's age or were consequent upon, linked or connected to her age, and then to treat those considerations as part of the relevant circumstances. The submission was towards the bottom of that paragraph. It was wrong in principle to take those matters into account in the comparison exercise. And the conclusions accepting that proposition, particular reference to paragraph 34, it's really the whole of the sidelined passage that is important, but particularly paragraph 34. In relation to race discrimination.
What do you want us to read?
Well, I'll direct you to the specific passage, my lord. To illustrate the point, it's obvious once such a comparator is identified, the tribunal cannot hold the relevant circumstances of the two cases to be different on the ground that the comparator is white and the complainant is black, and so regard the comparison as invalid. It would make a complete mockery of discrimination to do that, and that's even in a direct discrimination case. So, in this case, as well as the analysis being a broader, higher level comparative exercise, if you exclude women from the pool because they're women, it's tantamount to saying you can't compare men with women because men are men and women are women. And that's a nonsense in my submission.
It depends what the PCP is. It all depends.
I don't see that.
I mean, I can see your point that if an employer has a policy of sacking people who become pregnant, and that is challenged as on direct discrimination discrimination. The employer can't answer that by saying, oh no, we're not sacking them because they're women, we're sacking them because they've become pregnant and given birth. And I can see in those circumstances it would make a nonsense of the provisions to treat the criterion of being pregnant or having given birth as different from the criterion of being a woman, which is a protected characteristic. But I'm not sure that it necessarily follows from that you can't exclude them as being in a materially different position, because you're not excluding them because they've got pregnant and given birth. You're excluding them because they have claimed or are claiming maternity leave or maternity pay.
But they can only do that because they've given birth. It's only available to those that have given birth. Either pregnancy and maternity is indissociable from sex or it isn't, in my submission. The law can't have it both ways.
But the law does. Maternity and pregnancy are themselves a protected characteristic. And I've thought it's very long established now that you can't discriminate against pregnant mothers or mothers who've recently given birth on the basis that they're pregnant. These days, subject to cases about overseas companies and so on, like Carver and British Airways, an employer could not say, if you fall pregnant, you're sacked. And that's not because it's indirectly discriminatory against women, it's because maternity and pregnancy is itself a protected characteristic. But most unusually, there is plenty of European case law to say there's nothing wrong at all with advantaging pregnant and recently delivered mothers over everybody else. See the Pregnant Workers Directive, cases such as that, Maui and so on. And as Justice Underhill, as he then was, he said, it is possible to construct cases where the pregnant mothers are treated so favourably that it doesn't fall within the remit of the Pregnant Workers Directive and so on. In that case, every woman on maternity leave was given a top score and in effect exempt from redundancy. And the EAT said that it's not a blank check. But I suggest that the provisions which broadly track the statute may not exactly correspond with them, are on a proper analysis legitimate positive discrimination in favour of pregnant women or women who have recently given birth. That's what they were introduced for.
A number of points, if I may, my lord. The new Section 18 in the Equality Act is, in my submission, simply a codification of the European jurisprudence that went before. Section 18 works in a particular way, and there can still be circumstances where recourse is had to sex as the protected characteristic to bring essentially the same claim. As it happens, I have an appeal in the EAT in a couple of weeks' time in relation to a police officer on exactly that point, precisely because of the peculiar operation of Section 18. It's a codification of what's already gone before. It doesn't change the law to the effect that pregnancy and maternity are indissociable from gender. But in relation to your other points, my lord, the Pregnant Workers Directive requires member states to make available a certain amount of leave for health and safety reasons. It says nothing about the rate of pay that is received on that during that leave, which is the issue in this case.
So has to be adequate.
Has to be adequate, the Gillespie point, but beyond the adequate provision, which I would surmise is met in this country by statutory maternity pay, beyond that level, it's not a health and safety issue. So there's no health and safety imperative behind providing full pay to women on maternity leave. I would also say that whilst the leave must be made available by member states for health and safety reasons, we can't assume that any given woman that is taking that leave is doing so for health and safety reasons. It's optional. Many women may have uncomplicated births and recover quickly and want to go back and are able to go back to work after week 2 is over. But because they have more leave available to them, perhaps at full pay, they decide not to. Those women are not taking that leave for health and safety reasons. And there is a distinction between the exception, derogation, if I can call it that, my lord, which you referred to in your question. There are 2 levels of derogation provided for in the Equality Directive, the recast Equality Directive. There's one level is what is required of member states, and another level is what is permissible. That is broadly set out in the recitals to the recast Equal Treatment Directive, tab 7 of the legislation bundle. So recital 22 is what is permitted, recital 24 is what is required.
Which tab?
Tab 7.
Legislation. Yes.
So, in broad terms, recital 24 cross-refers to the Pregnant Workers Directive and health and safety considerations applying to pregnancy and maternity. Whereas recital 22 simply does not prevent member states from adopting measures providing for specific advantages. So, in the context of this case, when we're concerned with the pay that is received on maternity leave, I don't dispute that would amount to permitted special treatment of women on maternity leave for the purposes of a direct discrimination claim. That's why section 13 subsection 6 prevents a claim by a man for the same. But section 13 subsection 6 doesn't apply to section 19. So whilst full pay on maternity leave may be permitted special treatment, there's no block to a claim in relation to that under section 19. The statute only blocks the claim in the form of direct discrimination. And there's no obligation, EU law or otherwise, to offer full pay maternity pay. So it can't be said that that is received by women on maternity leave pursuant to the Pregnant Workers Directive or recital 24 of the recast Equal Treatment Directive.
So you would say that section 13(6)(b) prevents Mr. Hextall from claiming exact parity with maternity leave and maternity pay, so you accept that he can't claim to take leave before the birth of the baby, and he can't claim pay for as long as a woman is entitled to maternity leave. that would be blocked by section 13(6)(b), is that right?
If it's not blocked for other reasons of the correct comparator, in this case, Mr. Hextall is not asserting that he should be able to take maternity leave or receive maternity pay, but if he were, leaving aside the derogations in a vacuum, you might very well say that it's available to women, it's not available to men. Prima facie, it's direct discrimination, but then section 13(6) kicks in and prevents the claim for that.
So is that what prevented a claim before shared parental leave was invented or introduced for anybody, and the situation was simply that men were not entitled to any paid time off for looking after a baby, but women were entitled to maternity leave and maternity pay? What was it then that stopped there from being this kind of claim? Was it section 13(6)(b) or the equivalent?
In terms of the entitlement to leave, certainly special treatment in respect of women in terms of pregnancy, maternity, and in relation to the pay, domestically, section 13(6) would be the answer, because it's special treatment, but it's special treatment that goes beyond the health and safety requirement. Section 13(6) is not limited to blocking a claim for parity where there is a health and safety obligation giving rise to the special treatment of women. It goes further than that. Member states are free to improve upon the minimum requirements imposed by EU law, and section 13(6) does that and would cover the enhanced pay as well. But that doesn't apply in section 19 cases.
I think what my lady was asking was, why was the position any different before the introduction of parental leave, paid parental leave or shared parental leave?
Well, the answer is that there is a statutory block in the form of section 13(6). So the direct discrimination.
It would have had to have been a direct discrimination claim.
Yes.
Yes.
To ask for maternity leave and maternity pay.
Well, suppose there had been an employer who, even though statute didn't require allowed fathers to take a certain number of weeks leave at a certain rate of pay, less favourable than mothers, pre-2014. Could a male employee father have said your PCP is that you pay people who take caring leave other than birth mothers at a rate which is saying I should have said fathers or anyone else who's not a birth mother. Suppose an employer had a policy that if you could apply for leave to care for a child, whether you're male or female, that it's paid at a much lower rate, much less favourable terms than maternity leave. Would that have fallen within section 19?
Yes. The issue would depend on who that leave was available to. So if it was a right confined to men, then no, because the PCP would not apply to everyone. The critical point here is that shared parental leave is available to everyone, which is why women must also be in the pool. In the example you posit, my lord, if the situation had been that voluntary type of leave had been available only to men, then the claim wouldn't have worked because the PCP doesn't apply to birth mothers. But in a situation where the PCP applies to birth mothers as well, then there's no reason why the claim wouldn't have operated in exactly the same way. What has changed with the advent of shared parental leave is precisely that it's available to mothers and fathers, whereas previous forms of parental, paternity leave, for example, were not.
Are we still on which ground are you on now?
So, well, I'm focusing on ground 5 really, but I suppose I'm adopting a more thematic approach rather than ground by ground. So we've looked at Lockwood. I would also like to draw the court's attention to the case of Cole in the Supreme Court, please, which is at tab 31. This was a direct discrimination case. And briefly on the facts, it was about approved premises for released offenders and an aim of housing released offenders close to their home. And the situation was that the premises had to be single sex. And the premises available to female released offenders were very small in number, only 9, whereas there were 94 such premises available to men. So inevitably, it was much easier to house male released offenders close to home than it was for women. And those facts are set out in paragraph 11. But I'm particularly interested in paragraph 32. Concerning the material circumstances. Even in a direct discrimination case, which this was, Baroness Hale says, 5 lines into paragraph 32, that women had different characteristics from the men. Those being in this case that there were fewer of very high risk, and the criteria for admitting them to the approved premises were different. And the ultimate analysis was that those features were peculiar to women. So those were not material circumstances when it comes to the comparative exercise. You have to exclude those features that are peculiar to the particular gender group. She says the question of comparing like with like must always be treated with great care. Men and women are different from one another in many ways, but that does not mean that the relevant circumstances cannot be the same for the purposes of deciding whether one has been treated less favourably than the other. Usually those circumstances will be something other than the personal characteristics of the men and women concerned, something extrinsic rather than intrinsic to them. So the material circumstances in this case were simply that the offenders were being released on condition that they live in approved premises. Those were the only material circumstances. So in this case, for purposes of a direct discrimination analysis, the material circumstances are simply that the comparators must both actually be taking shared parental leave. That's what's important. We don't need to know, actually, that a woman taking maternity leave has given birth and what the purposes maternity leave are said to be in pursuit of. It doesn't matter. The material circumstances are comparators are on shared parental leave. And in those material circumstances, there's no direct discrimination. When we come to the indirect discrimination circumstances, what is material is that the PCP applies, or everyone in the pool is affected by or interested in the PCP, That's what's material for section 19. And that is why women on maternity leave must be included. So, on that premise, if the fact of giving birth is out of the equation because it's not a material circumstance, even the mother who is taking maternity leave is simply taking leave. That's in no way different from a man who is taking shared parental leave. As Baroness Hale says in Esser, in paragraph 39, there's nothing peculiar to womanhood about taking a greater share of caring responsibilities. Further point that I would add is that if we start inquiring into the reasons why women are taking maternity leave, we make too many assumptions. As I think I've already submitted actually, we can only assume that 2 weeks of leave is compulsory. We know that must be the case for all women. But beyond that, we don't know why any given woman is taking maternity leave. No woman is required to fill out any form or undergo any medical assessment to establish that health and safety reasons are at play. We don't need to know why she's taking maternity leave. Not least because, in this case, the entitlement to the leave is not the issue. It's the rate of pay that's received that is the issue. And just finally, I would observe that I need to correct something that I said. I objected to a submission that, I corrected a submission that Mr. Bassoon made about whether women are required to take 2 weeks of leave, maternity leave, before they can take shared parental leave.
Yes.
I have since myself been corrected by learned friend Mr. Burns, because there are some other regulations that are not in the legislation bundle, which said, despite what I said, there are curtailment regulations, so that the mother, in order to start her shared parental leave, has to issue a curtailment notice, and those other regulations say that she can't do that until after she's had 2 weeks of maternity leave first. So I have to correct what I said earlier. But leaving that point to one side.
Right, so she could only have shared parental leave after she's taken 2 weeks of maternity leave.
Yes, I was wrong about that. But still, the thrust of my point holds good insofar as we're concerned with the period after those 2 weeks. To the extent that the so-called purpose of maternity leave is relevant, that purpose must equally apply to shared parental leave, because the birth mother herself, after 2 weeks, can fulfil the health and safety purpose of the Pregnant Workers Directive by taking shared parental leave. She's in no way required to take statutory maternity leave in order to do that. So the health and safety purpose of the directive is fulfilled equally by use of shared parental leave for her as it is by use of maternity leave. That's a further reason why I say the purpose of maternity leave is neither here nor there.
So the purpose of maternity leave is neither here nor there. For what purpose?
What the EAT says.
Neither here nor there for what? The inclusion in the
For
pool?
for determining whether birth mothers should be excluded from the pool. Fundamentally, I say that the purpose of maternity leave is a distraction, a sideshow from the real issue, which is what are the material circumstances, those being interest in or being affected by the PCP in this case.
Well, that defines who goes into the pool. But the point that I've been making to it, it seems to be to have borne out rather than undermined by paragraph 32 of Cole, is that what we're really talking about, and what she's talking about in paragraph 32, is finding what is the shared material circumstance relevant to establishing that there's been a particular disadvantage. That's what she's doing. So you have to be very, very careful, as I understand. She's saying in paragraph 2, first of all, you have to be very careful about the question of comparing like with like. She's saying it all depends on the circumstances. This is a case of direct discrimination. And so the question in this case was, is there a material circumstance, albeit men are different from women, but is there a material circumstance which they share for the purpose of seeing whether there is a disadvantage? Because there's no question of pooling in that case.
No.
It's a direct discrimination case.
Yes.
And she's saying, well, true, they are different, but one thing they do share, which is material, is the fact that they are all required to live in an AP.
Yes, so translating that to section 19 and the circumstances of this case, I say that what is material is the interest in the PCP. Birth mothers are just as much interested in the PCP of the rate of pay for shared parental leave as anybody else.
Yes.
That's what's material. And the fact that she may have given birth is immaterial.
Yep.
Insofar as the purposes of maternity leave are relevant, I say they're not. But I would stress that the Hoffman judgment predates even the advent of the Pregnant Workers Directive. And the purpose that Mrs. Justice Slade relies on in her judgment in the Capita case is derived from the health and safety purpose of the Pregnant Workers Directive.
So what do you say about Hoffman? It's out of date.
Yes, essentially.
Yes. Yes.
It expresses. I mean, there is a learned friend, Ms. Lombard, is going to deal with that in their case. It's not something that features strongly in ours. So, just going back to my survey of the issues. Ground 7 is no longer effective. As I say, I'm content to rely on my written submissions in respect of ground 6. And unless there are further questions, that concludes my submissions.
Any further questions?
Can I just go to Cole, the last case you referred us to? And if you look at the beginning of 29, the exact correspondence test is only relevant where the actual criterion used by the alleged discriminator is not a protected characteristic but something else.
Yes.
Is that relevant to the present discussion?
It's relevant to the James and Eastleigh point raised by the Chief Constable. It's a reiteration, effectively, of paragraph 17 of ESSOP, and Baroness Hale says the same thing. The reason why James and Eastleigh was direct discrimination was because the rule at play was a proxy for gender. The rule was you get in free if you're retired, but at the time that meant women got in free and men didn't. And
retirement is not a protected characteristic. Pregnancy and maternity is.
But this is not a direct discrimination claim. All paragraph 29 is saying is that the circumstances of Cole were different from the circumstances of James and Eastleigh, but it's still a direct discrimination claim for the reasons that Baroness Hale describes, because it's a reason why case rather than the rule being a proxy for gender. This case is not a reason why direct discrimination case, it's an indirect discrimination case because the PCP applies to everyone, and it's not the case that that the male group is 100% disadvantaged and the female group is 100% advantaged. The fly in the ointment that prevents it from being a direct discrimination claim is the presence of female partners of birth mothers who are also disadvantaged in the same way as the men. So that's why this is not a direct discrimination case. And all Baroness Hale is explaining there is why this case was different from James and Eastleigh, my submission.
Final question, Mr. Lee. There is a well-known recent example, as it happens in political life, of two candidates for a high position, one of whom had had children, one of whom had never had children. The one who'd had children said, I'm better qualified to occupy this post because I've had children. Now, suppose you had an employer, say a local authority, that advertised a post of maternity advisor and said, this is only open to candidates who have had children. Would that be direct discrimination or indirect discrimination?
Well, it would be not necessarily either, I don't think. The requirement of having children is not the same as the requirement of having given birth. Having children can be fulfilled by males or females.
Sorry, I didn't spell it out clearly enough. Candidates will only be considered if they have themselves given birth to at least one child.
That's direct discrimination.
Because
Only women can do it.
yes, but the disadvantaged group includes women who've never had children.
Yes, this is the same situation that is posited effectively in the surrogacy cases, which Murder for Mr. Burns is no doubt going to refer to. So the issue there is commissioning mothers who've not themselves given birth sought access to maternity leave. The circumstances of the two cases are essentially the same, and the answer that the ECJ gives is that it is not indirect discrimination because the females are affected in the same way as males who might have commissioned a surrogate to give birth. The point being that maternity leave is only available to those who have actually given birth. And that's different from this case precisely because shared parental leave is available to everyone whether they've given birth or not. And it's enhanced maternity pay is only available to those who have given birth, but that is the context factor in the case. So I say that the surrogacy case analysis, which is essentially the same as the proposition you put to me, my lord, is something of a red herring when translated to the circumstances of this case.
Right. Any questions? I think we have David indicated we're not going to ask for a reply at this point on Hextall. Right, so what we're going to do, I think this is what you'd agreed. We're not going to ask for a reply on the Hextall case at this point. We're going to go straight into the Alley case and hear the appellant on Alley. And I think that's you, Mr. Mandala, is that right?
Just provide
Just rearrange the furniture.
Yes.
Thank you, Madam Secretary. You have heard in some detail some of the arguments that are going to be addressed by me during the course of my submissions. Can I say that it does fall to me to remind this court that at the heart of this matter we are dealing with the stuff of ordinary and everyday lives, and Mr. Ali, who sits behind me, is the proud father of a daughter now 3 years old who has brought a claim in the Employment Tribunal in respect of pay in relation to shared parental leave, and his wife has returned to work. Can I, in the light of both observations that have been made during the course of the submissions that you've heard already, and also some observations that are contained in the written submissions on behalf of working families, just make 2 short points. Firstly, it's right that I say that this case is not about taking away anything from women, whether those women are pregnant, have recently given birth, or are breastfeeding. This case is about recognising the possibility of giving something to men, something which is valuable, recognised not just by society, but also by courts, and recognising the rights that Mr. Ali asserts does not take anything away from the rights of women. I do think it's important to make that point.
Yes.
Equally, this case is not about whether it is legitimate or proportionate to provide advantageous maternity leave to protect the health and safety and well-being of women. It is about whether a father who wishes to take time away from the workplace to care for his child should be given a meaningful opportunity to do that. And that meaningful opportunity must, we say, include an opportunity to obtain the same pay as a woman who is carrying out that same task. Having said that, and before I take you to the way in which the Employment Tribunal approached the matter, can I give you an overview of the way in which the appellant frames this case?
Yes, thank you.
There is, of course, a point of principle and policy that is of importance, and it relates to the implementation of equal treatment in relation to parental pay and leave. And my central submission, which I will develop time permitting, is that where you are in a regime where a woman has the right to curtail her maternity leave and to transfer a particular portion of that leave to her partner, then it necessarily follows that the portion of leave transferred ceases to be maternity leave and becomes leave which is directed for additional and other purposes. And those purposes are, in my submission, to facilitate the care of a child. So at the point at which transfer is possible, we say, the leave becomes leave which is not connected with a special condition of pregnancy or childbirth. It becomes leave which is for the purpose of, paraphrasing it, childcare responsibilities. And
What is the significance of that?
the significance of that is that whereas in Mr. Ali's case, you have an employee, a male employee, who wishes to compare himself to a female employee 2 weeks post-birth, and the purpose of the leave is to care for a child, that is a comparable circumstance. The circumstances of the two are materially similar, we submit, and so it becomes a legitimate comparison for the purposes of a direct discrimination complaint. And in those circumstances, one then looks at whether or not that comparison, properly explored, is affected in any way by the provisions of section 13(6)(b). And if it's not, we say it results in a claimant in Mr. Ali's position being able to maintain a complaint of sex discrimination at an employment tribunal.
Okay, so the analysis is at the moment that the man, the partner, at the moment that the man wishes to claim shared parental leave, his wife has given, he's only entitled that because his wife has given up her maternity leave.
Yes.
And therefore, you're saying on its proper interpretation and application, the disbar in section 13(6)(b) doesn't apply. That's what it comes to.
Yes. Can I perhaps regroup a little bit and try and make it more straightforward? What I say is that after 2 weeks after birth, whatever the label that is placed on the leave, given to a woman or to a man, it is essentially leave which is for the purpose of facilitating the care of a child. It's our submission that the introduction of the shared parental leave regime represents a significant change in the legislative landscape. It is a change which does not affect entitlement or rights to maternity, but it provides additional rights to those, whether they are fathers or partners, to take leave to care for their child. So one of the things that...
Did the compulsory 2 weeks leave,
Yes.
the provision for that in the regulations predated the introduction of shared parental leave?
Absolutely.
Yes.
Absolutely. And it may be easier to understand my submissions if I can take you through the various pieces of legislation and start perhaps with the European framework before descending to the domestic legislation. But before I do that, can I just make some further observations about the underlying policy to the introduction of shared parental leave, which I think...
But can I, while I'm the amendment,
Yes.
can I ask a question, please?
Yes.
So you say that after 2 weeks...
Yes, which is the compulsory maternity leave period
Yes.
provided for in the pregnancy,
Right, yes,
pregnancy
after 2
directive.
weeks, what you're concerned with is nothing to do with child warmth or maternity as such,
Yes.
but to do with the facilitation of the care of the
Yes.
child. Well, I'm slightly surprised about that in one sense. I can see why you're saying it, but I'd understood that certainly, I think, at the European level and domestic level it may be, there are a whole series of reasons that were given for the need for maternity care, what it was aimed at.
Yes.
And I think there was one case which listed about 6 of them, and they were, the last one was it was care of the child, and the other were to do with other things relating to motherhood and childbirth and so on. Why should the introduction of shared parental leave, which can be taken after 2 weeks, as it were by itself, change the nature of that those composite reasons for maternity leave and pay? This is what you seem to be suggesting.
Well, my lord, there are a number of things that we say have affected the legislative landscape. Some of those considerations are policy considerations which have been brought into play since the European jurisprudence that you're referring to. My lord, I think you have in mind the Hoffman case.
Yes, well,
that precedes, first of all, the existence at European level of any parental leave directive. It precedes the policy statements that have subsequently emerged, which emphasise that as part of the struggle to achieve equal treatment as between men and women, traditional gender roles must be challenged, and support must be given not just for women to take up their maternity rights, but also to return to the workplace. And that support includes the ability of their partners to be able to take on the burden of childcare responsibilities if they so choose. So that's a significant development, and it's a development which, as I say, postdates the jurisprudence in Hoffman and the like. The other matter is that from a policy perspective, giving women choices has been recognised within the European jurisprudence as paramount to enable the social change which sits behind both the Pregnancy Workers Directive and the Equal Treatment Directive. It is about facilitating choice. And that approach is in my submission, and I hope I will be able to make it good when we look at the authorities. That is a development, both in terms of policy and law, which is not really recognised in Hoffman and the like, and is increasingly important. So that's what has changed from a policy perspective. What's changed from a practical perspective in the legislation is that the shared parental leave regulations require a decision to be made to curtail maternity leave. So that decision is, in my submission, a very clear example or illustration of the nature or the purpose of the leave being materially changed. The health and safety considerations which are protected are no longer weigh so heavily in the equation. The 2-week period is designed to reflect that. After the 2-week period, there has been a decision effectively by Parliament in the enactment of these regulations that says after 2 weeks there is a caring role to be done, and it can be done by father, mother, partner.
Yes, but not yes, that's true, but it's a matter of the facts and circumstances and the choices made in each case.
My lord, yes.
And that is, if you're making the broad submission that after 2 weeks the only issue is one of childcare, not one of the other matters mentioned in Hoffman, that goes too far, doesn't it? It just depends on what the facts of each case are.
Well, my lord,
the choice is made in each case.
Well, my lord, we certainly in the Ali case are faced with an employment appeal tribunal judgment which says effectively the primary purpose of maternity leave, whatever its duration, is to secure the health and well-being of the mother. So that's where we are on the one hand. On the other hand, we have regulations which say after 2 weeks, anyone with the appropriate relationship to the birth mother can take on caring responsibilities. So as a matter of logic, the appellant says the 2-week point, clearly defined in regulation, is a rational point to identify as the end point of the health and safety obligations, and that thereafter, if one is simply on a sliding scale, so to speak, trying to identify, well, if the maternity protection doesn't end after 2 weeks, but it ends after 6 weeks, one of the suggestions made by the respondents, because that's the rate, that's the point at which the pay rate's changed, or after 12 weeks, because there is no principled position in relation to when maternity ceases to be about the health and well-being of the mother, other than the position that after 2 weeks, provided for as compulsory maternity leave, the election can be made. Having set out my stall in that rather broad ways, my lords, can I take you, I hope briefly, to some of the provisions, just so that you, I think we have considered some of them along the way, but it's probably helpful just for me to identify where we are. If I start, and my lords, I think you've been taken to this with the maternity leave provisions, insofar as we need to look at them. If you, my lords, my lady, have the legislation bundle behind tab 16 rather, we have the relevant the maternity and parental leave regulations. I think for my purposes, my lord, I can summarise the nature of the relevant rights and entitlements. There is a total of 52 weeks statutory maternity leave. 26 weeks of that are ordinary maternity leave, and 26 weeks are described as additional maternity leave. And at page 8 of the internal numbering behind tab 16, my lords, my lady, you see the regulations that provide for those matters, at regulation 7.1 and 7.4 in particular. The upshot of the regulations is that maternity leave can commence up to 11 weeks before childbirth, and you will also see, my lord, my lady, if you turn over the page to regulation 8, the provision that prohibits an employer allowing an employee to attend work during the compulsory maternity leave period. And you'll see that at 8b, it is specified that the period is 2 days, commencing with, 2 weeks, commencing with the day on which childbirth occurs. And then there is an associated right to maternity pay, statutory maternity pay, during periods of maternity leave. My lords, my lady, I don't propose to take you to the pay provisions, but they sit, and it may be helpful for your notes, behind tab 12.
Sorry, where is the bit about being able to start taking the leave before?
11 weeks. That, my lady, is at regulation 7.1. Continues for 26 weeks, and my lord, yes, thank you. The additional leave is at subsection 4.
So, which tab are we in now?
We're still in tab 16.
Okay, so tab 16.
Tab 16.
Yes.
These are the maternity
Yes, we've looked at
pay
these.
regulations. I think we've looked at
Which
these.
was the additional paragraph 4?
It was 7.1 and 7.4.
Yes, you've seen those.
Yes, and sorry, to answer my lady's question, if I can take you back to regulation 4.2b, that is where you'll find the provision specifying the earliest date at which maternity leave can begin.
Yes.
you've heard that the effects of the statutory maternity pay provisions are that there is a qualifying period of continuous service to receive that pay, and upon meeting the qualifying conditions, maternity pay is payable for a total of 39 weeks, and the highest rate of pay is either 90% of normal weekly earnings or a fixed statutory rate. And that is for the first 6 weeks, and thereafter it is paid at the lower rate. That is as far as I propose to delve into the maternity leave provisions.
So if you take leave after the 39 weeks, then it's unpaid.
Well, it's additional maternity leave, and there is no provision for payment, although of course it is possible for employers to choose to pay sums in respect of additional maternity leave periods.
And that's all in here somewhere, is it?
Yes. My Lord asked the question as to what the leave provisions were before we reached the shared parental leave provisions. And whilst again I don't want to dwell on it over long, it is right that there were provisions in relation to paternity pay, which preceded the shared parental leave regulations. Those provisions had eligibility requirements, unsurprisingly. I don't think I need to trouble you with those, but what is significant in my submission about the preceding paternity leave provisions was that there was an opportunity for fathers and partners to take paternity leave, but they were only able to do that after the 20 weeks of ordinary maternity leave. So whilst there was the opportunity to curtail maternity leave on the part of the mother in order to give father, partner the opportunity to take leave, you were not able to exercise that right until 20 weeks.
After the birth?
After the birth.
Or after the start of the maternity leave?
After the, let me just be clear, I don't want to get this wrong.
Well,
It was 20 weeks following the birth.
when you say partners, paternity leave was available for fathers or partners?
Well, as
Is
in,
it just men?
yes. There were other. I'm not. There were other. There was other leave available. There was other leave available. So same-sex partners were able to take advantage of those provisions.
So there were some women who could take paternity leave before shared
Yes,
parental leave?
there were.
Now, where does this fit into the analysis?
Well, it was simply to firstly answer the question about what the arrangements were before shared parental leave, but it fits into the analysis also because in terms of previous litigation where discrimination claims as between mothers who had caring leave and fathers or partners who wished to have access to leave at the same rates of pay, there were challenges along the lines of the challenges that are brought in this case. And one of the obstacles that those challenges met was that there was a 20-week period before maternity leave could be curtailed and paternity leave could be taken. And that 20-week period was often described by employers as necessary for the purposes of fulfilling legal obligations to the mother in terms of securing her health and safety and well-being, and necessary to foster the special relationship between mother and child. And those are arguments that you will have heard and read raised in this case and others that we will perhaps look at. So that's why I touch on it there. If I can then, my lords, my lady, move to the shared parental leave provisions. You have... Sorry.
Just going back to that last
Yes.
Prior to the introduction of parental leave, you said that the 20-week period was said to be necessary to protect the mother. Did any court here or over the channel hold that wasn't so?
That it wasn't necessary?
Yeah.
My lord, no. I'm not aware, my lord, of any authoritative cases on the matter. There were a number of first instance employment tribunal cases on the matter. All of the ones that I'm aware of were unsuccessful, including one that I myself was involved in.
All right, but you're saying that the introduction of shared parental leave
Yes,
entirely changes, that brings the bound
yes,
to the end of week 2.
yes,
And from week 3 onwards,
yes.
there is nothing special about the fact that the birth mother gave birth.
Indeed, indeed. My lord,
When
then
you
if,
talk
if
about
sorry,
cases having failed,
Yes.
you were talking about cases brought by men
yes,
complaining that they were not getting what? Getting
pay, that they were not able to receive pay during parental leave, which was comparable to the pay which women on maternity leave were receiving. And I think it would be fair to say that those cases were cases of direct, indirect and equal pay. So they ran the gamut of the matters that have been canvassed
Are
before.
any of those in the authorities' bundle?
No, because as far as I am aware, none of them reached appellate level.
Are we talking about this is claims by men for equal,
Yes.
for equal pay?
Using that term loosely,
I know,
yes,
but-
yes,
but
but using the
commas,
term, yes,
or the same rate.
yes,
That's
the,
better.
the same rate,
The same rate as for maternity.
effectively, yes.
But I'm just trying to work out at what point. What are they saying, that before or after the 20 weeks? I'm not trying
Well,
to work that out.
there have been a number of cases, and they variously adopted positions which were before 20 weeks. Some of them related to the 14-week period that you've heard something about. Others adopted the 2-week compulsory leave period. So there have been a range of propositions put forward.
All right. So can I put it like this? So before the shared parental leave provisions came into force, there were a number of claims by men in relation that they should have leave and that they should be paid at various stages from the 2 weeks
Yes.
onwards.
Yes. Yes.
For a comparable treatment as for pregnant women
Yes.
and women giving birth.
Yes.
I see.
So I gather from that the reduction of the 20-week period to the 2-week period occurred before the shared parental leave
No,
regime.
the reduction occurred with the introduction of the shared parental leave regulations, because prior to that there was always the compulsory 2-week maternity leave period, as you've seen prescribed in the directive. But the opportunity for the woman to make the election did not occur, could not occur before the 20 weeks after childbirth.
And I should know this, I can't remember. Prior to the introduction of paternity leave at the end of 20 weeks, did fathers have any statutory rights to leave at all? A, paid, B, unpaid?
There was a right to 2 weeks unpaid paternity leave.
Same 2 weeks?
Yes, indeed.
But apart from that?
Apart from that, there were no specific provisions.
And is the point that after 2 weeks, following the introduction of the shared parental leave provisions, everything changed in the sense that whatever happens thereafter is to be considered as just a facilitation for looking after the child? Is that the whole of is that your argument for saying that a direct discrimination case applies, or do you have other points as well?
There are other points as well.
Okay, fine.
The question, one of the questions posed, I suspect not rhetorically by the respondents to this appeal, is, well, what has changed about the nature and purpose of maternity leave? And the suggestion made is that nothing has changed, and these shared parental leave regulations leave the legal landscape completely unaffected. And what I say on behalf of Mr. Ali is that these regulations and the opportunities that they provide to both mothers and fathers and parents absolutely and significantly changes the landscape.
Thank you.
And with that in mind, can I ask your lordships, my lady, to turn to tab 17, which is where we will find the shared parental leave regulations. And I don't propose to take too much time in terms of looking at them, but I think I must take you, again using the internal page numbering, to page 6, where we have regulations 4 and 5, which set out the entitlement to shared parental leave. Regulation 4 deals with the mother's entitlement, Regulation 5 to the father's entitlement. And you'll see that for both there is a condition that they have the main responsibility for the care of the child apart from the corresponding partner. And you'll see in relation to the mother that she must be entitled to statutory maternity leave in respect of the child. And here's where, in my submission, we see the beginnings of the development that I've outlined. At D, in relation to the mother, she must have ended any entitlement to statutory maternity leave by curtailing her leave, or if she has not curtailed her leave, she must have returned to work before the end of her statutory maternity leave. So you see very clearly that there is a termination of maternity leave for the purposes of transferring the balance of that leave, whoever that may be, to. It's, I think, common ground between the parties, so I won't dwell on it, that one of the purposes of the introduction of these regulations was to create choices for families, as to how they look after their children, and to create more equality in the workplace and reduce the gender disadvantage that results from women taking longer periods of time out of the workplace on maternity leave. I think my learned friend Mr Burns sets out those matters in his skeleton argument at paragraph 12, and the appellant takes no issue with those. There is associated with leave, the shared parental leave, parental pay provisions. Again, I don't propose, given the time available, to take you to those. The upshot of those provisions, again, I would accept as fairly summarised in the skeleton argument of my learned friend Mr Burns at paragraph 14. What my lords, my lady, I hope is clear from even that brief look at the maternity pay regulations and the shared parental pay regulations, is that there is a close connection between the mother's right to maternity leave, statutory maternity leave and pay, and the father's right or the partner's right to shared parental leave. So there is a link between the two. What the point of difference between the appellant and the respondent in this case is that the respondent's position is that whatever the time, however long it is post-birth, the purpose of maternity leave, simply by reason of it being described as maternity leave, is entirely different and not comparable with the purpose of other leave to look after a child. And we simply do not accept that proposition. So if I just stop for a moment, the effect in my submission of the shared parental leave regulations is that there is a period of 2 weeks non-transferable statutory maternity leave. That leave is compulsory. And thereafter, up to 50 weeks of parental leave is available to either the mother or the father to care for their child. And that leave can be taken as maternity leave, or it can be taken as shared parental leave. And there is a consequence in terms of pay, depending on which of those choices are made. My Lord, if it is convenient, I wanted to just briefly take you to the directives and the relevant provisions. Again, I hope, my Lords, I can take this with a relatively light touch because certainly a number of the provisions that I propose to draw your attention to have already been referred to in argument. But it is, in my submission, helpful to consider the features of the EU legislation and some of the authorities in order to understand what the legal underpinning from a European law perspective is for the parental leave rights and for equal treatment. And also, I think this exercise casts light, which is helpful, on the policy aims and the principles which underpin this area of law. So if I can, whilst we're still in this bundle, invite you to turn to tab 3. And behind tab 3, we have, I hope, I think I may have taken you to the wrong tab. Just bear with me. Sorry, it's behind tab 2. we have Council Directive 92 of 85, and you will see that this introduces measures to encourage improvements in the safety and health at work of pregnant workers and workers who have recently given birth or are breastfeeding. And the title in my submission is instructive. It clearly indicates that this measure was introduced as a health and safety measure, and that this directive was introduced in respect of 3 categories of people defined, we will see later on, in Article 2. It's focused at pregnant workers, workers who have recently given birth, and workers who are breastfeeding. And you will see in Article 2, 3 over the page in the definition section, that what those terms mean is a matter to be determined in accordance with national legislation or practice.
Where are we looking at here?
That's if one turns over the page, my lord, to the second page of the directive, you'll see in Article 2 there is a definition section, which, as is quite often the case, doesn't necessarily define anything, but tells us where we must look for our definition. And then, my lords, if I can ask you to turn on to Article 8, which I think is 2 pages on. You will see at Article 8.1 that Member States are required to take necessary measures to ensure that workers within the meaning of Article 2 are entitled to a continuous period of maternity leave of at least 14 weeks, allocated before and after confinement, in accordance with national legislation or practice. So, pausing there, that's where, in some of the earlier cases, the 14-week period in terms of leave can be derived from. And you'll see at Article 8.2 that the maternity leave stipulated in paragraph 1 must include compulsory maternity leave of at least 2 weeks, allocated before or after confinement. So that's the requirement which led to the implementation in response to that requirement, led to the regulations in terms of maternity leave that we've just looked at. So pausing there, I do observe that the focus of that directive is on specific circumstances that are unique to pregnant women or women who have recently given birth. The minimum period of maternity leave in domestic legislation is of course more generous than the annual period of maternity leave in domestic legislation is more generous than the 14 weeks provided. And that is, of course, a matter for domestic legislatures, national legislatures.
But where does it deal with what should be paid during those 14 weeks?
There are no provisions in the directive that deal with pay. What is said in terms of being able to give effect to that leave is that there must be an adequate allowance. And you've heard reference to the Gillespie case, which establishes that principle.
That's in the case law, not
Yes.
not in the directive itself.
That's right. It relates to the proposition that in order to have an effective right, one must have a means of actually enforcing it, and that the allowance in respect of pay whilst on maternity leave should be. Oh, thank you. stage whispers left and right, direct me, my lord, my lady, to Article 11, 1 and 2.
Yes.
So perhaps we can go there. Thank you. Yes, I'm grateful. You'll see in Article 11.1, the employment rights relating to the employment contract, including the maintenance of a payment to and or entitlement to an adequate allowance for workers within the meaning of Article 2, must be ensured in accordance with the national legislation. And similarly, in relation to maternity leave, Article 8.2 at B deals with the maintenance of a payment or entitlement to an adequate allowance. And you'll see also in 11.3 how adequacy is, or one of the ways in which adequacy is to be assessed. If I can next show you, and I think this sits behind tab 3, again, just briefly, the first occasion on which specific provision in respect of parental leave for both parents was made at directive level. And you'll see that behind tab 3 we have a framework agreement on parental leave. I don't want to take too much time on it because initially this did not extend to the UK, but it was extended with effect from December 1999, and it was extended by Directive 97 of 75. I don't think that we necessarily need to go there. What we have ultimately, and what assists us at this point, are the provisions in the, I apologise, my numbering seems to have gone awry, in the framework directive and the recast parental leave directive. Perhaps I can take those in turn. So the directive extending parental leave provision, the framework agreement to the UK, you see behind tab 4. As I say, I don't think that we need to dwell over long on it. The next document, which I think it is helpful to look at, is the framework agreement of 2000. That's behind tab 6. And again, you've been taken to a number of passages in this document, both in skeleton argument and in oral submission, so I don't want to labour the point, but you'll see the provisions relating to the principle of equal treatment between men and women in paragraph 2 of the preamble. It's described as being well established as regards access to employment, vocational training and the promotion. Sorry, this is at this is
tab 7.
tab 6. I'm sorry, tab's not being clear.
Tab 6. And my fault.
Yes.
Tab 6. My fault. Tab 6.
Tab 6, and I'm simply looking for the moment at paragraph 2 of the preamble, which deals first of all with the principle of equal treatment. It extends, you'll see, to working conditions. And you'll see from a policy objective in paragraph 3, the aim is to eliminate inequalities and to promote equality between men and women, especially since women are often the victims of multiple discrimination. And at 9, employment and occupation are key elements in guaranteeing equal opportunities for all, and they contribute strongly to the full participation of citizens in economic, cultural and social life, and to realising their potential. This directive was then replaced by the directive we have behind tab 7, which is styled a directive on the implementation of the principle of equal opportunities and equal treatment of men and women in matters of employment and occupation. And we have, I think, perhaps referred to it in our submissions as the recast framework directive. Here you can see the policy objectives underpinning the specific provisions that follow. And what I want to do, I think, given the time that we have, is simply draw your attention to matters which are set out at paragraph 21, first of all, of the preamble. This is, I think it's 3 pages. So paragraph 21, prohibition of discrimination is without prejudice to the maintenance or adoption of measures intended to prevent or compensate for disadvantages suffered by a group of persons of one sex. So some measures permit organisations of persons of one sex and so on. That's the provision which my learned friend Mr. Leach in his submissions described as being a permissive provision in relation to positive action. And then, my lords, my lady.
He referred to 24 as well.
Yes, he did. And I was just going to take you down to that, so you can see there that this framework, recast framework directive, is without prejudice to the measures to encourage improvements in the safety and health at work of pregnant workers and workers who have recently given birth or are breastfeeding. So reflecting the language that we've previously seen in the
23 as well.
Yes. Yes. And it's a theme, or it's a point that I suspect I will be coming back to, but it's, as the recital makes clear, it's unfavourable treatment of a woman related to pregnancy or maternity that constitutes direct discrimination. So those are circumstances where pregnancy and maternity are a protected characteristic. And
where are you referring to?
Sorry, 23.
23.
Yes, I apologise. 23.
Direct discrimination.
Yes. So that is set out there. What I wanted, if I may, to draw your attention to is to 25, which says that it is appropriate for reasons of clarity to make a express provision for the protection of the employment rights of women on maternity leave, and in particular their right to return to the same or an equivalent post. So again, dealing with rights and entitlements of women on maternity leave, intending or having taken that leave. This is the point, which is the from which those rights begin to emerge. The legislation that we will look at shortly, the Equality Act provisions, implement these obligations. The final passage that I wanted to draw your attention to in terms of this part of the document is at 26. This is a reference to the resolution of the Council of the Ministers for Employment and Social Policy in June 2000. The resolution is often referred to as Resolution 2000, and the resolution met to discuss, as you can see, the balanced participation of women and men in family and working life. And the result of that meeting was that member states were encouraged to consider examining the scope for their respective legal systems to grant working men an individual and non-transferable right to paternity leave while maintaining their rights relating to employment. Two things I say about that provision. Firstly, the fact that there is an express reference to it in the recast framework directive means that we must bear it in mind and take it into account when we are construing and applying the Equal Treatment Directive and its prohibitions on discrimination.
What that recital says to me is that they weren't actually able to agree at the meeting what provision there should be.
Indeed, it's not saying that it's not saying that there was agreement. It was saying that it was agreed that it was a good thing, if I can be colloquial for a moment.
Well, they were encouraged to think about whether
yes,
it was a good thing.
Yes, and to look at. So that I'm not suggesting that there was an agreement at the council, but what there was a recognition that the balanced participation of women and men in working and family life was a legitimate objective for policy and legislation in relation to employment and working conditions. And if I can just very briefly take you to that resolution, which you'll find behind tab 9. We can see, in terms of identifying some principles, again at paragraph 2, the principle of equality between women and men makes it essential to offset the disadvantage faced by women with regard to conditions for access to and participation in the labour market, and the disadvantage faced by men with regard to participating in family life, arising from social practices which still presuppose that women are chiefly responsible for unpaid work related to looking after a family, and men chiefly responsible for paid work derived from an economic activity. So, identifying fairly and squarely a problem to which policy and indeed legislation may be directed in due course. And the consequences of having identified that policy imperative we see in paragraphs 3 and 4. So the principle of equality between men and women in relation to employment and labour implies equal sharing between working fathers and mothers, in particular of time off work to look after children or other dependents. So, and we will come on to this when we look at some of the cases. This is, in my submission, a material shift in emphasis and tone in terms of policy and principle, because it explicitly recognises that in order to achieve equality of treatment as between men and women, one must look at relationships in terms of time off work to look after children and dependents, and consider those matters from the starting point that equal sharing facilitates the achievement of equal treatment. And in paragraph 4, we see why that is so, and it is because the balanced participation of women and of men in both the labour market and in family life is an advantage to both men and women, and is an essential aspect of the development of society, and maternity, paternity and the rights of children are eminent social values to be protected by society, member states and the community. So it's my submission that this sets out very clearly a change in tone. It's not a resolution that the cases that we will look at, Hoffman and others, had the opportunity to consider because it precedes those cases. So in terms of the landscape, the social and policy values that fed into those decisions, this clear statement of principle was not a matter which the court in those cases had the opportunity to consider. And then, just if I may draw your attention to paragraphs 10, important to protect.
Are you saying that the principle of equality between men and women, which is espoused and promoted in this directive, of talking about June 2000, are you
Yes.
saying that this principle of equality was for the first time mentioned? I'd be surprised about that. It must
No.
be an essential part, I'd have thought, of CJEU jurisprudence going back for years.
My Lord, yes, of course, you're quite right. That's not what I'm saying. What I'm saying is that in this resolution, one has recognition for the first time that an aspect of that equal treatment as between men and women is the sharing of time off work to look after children. So that is a feature of equal treatment of men and women. It's not a different thing or a separate thing. It is an aspect of it. And this says it very clearly.
Yes.
And can I just invite you to read paragraph 11, which rather poetically says, the beginning of the 21st century is a symbolic moment to give shape to the new social contract on gender, in which the de facto equality of men and women in the public and private domains will be socially accepted as a condition for democracy, a prerequisite for citizenship, and a guarantee of individual autonomy and freedom, and will be reflected in all European policies. So a clear statement of the policy objectives of the EU in terms of achieving equal treatment as between men and women in all spheres.
But they didn't follow through with that, did they, by introducing a right to 14 weeks paternity leave.
My Lord is right, they did not. There was a draft directive which, for various reasons, and I'm not going to, at this point in the morning, mention the B word, but there was a draft directive. It was not. It was not agreed. There was no agreement as to its terms, and so there was much discussion of what paternity entitlements, if any, should be provided, and there was no resolution to that. So
the member states were prepared to sign up to this aspirational
Yes.
document, but not actually prepared to commit to doing
Yes.
anything about it.
yes. And my lady's terminology is entirely apt. You will see at the rest of the page various declarations and encouragements, but nothing concrete. What we have in my submission then is a European framework which identifies, as I say, some legal requirements, but also some aspirational policy directions that signal the way forward, as they say, in the modern 21st century to ensure equal treatment. And I do submit that those matters should be factored in to an interpretation of the legislation, should be borne critically in mind when one considers case law which predates those matters, and that those policy considerations are a legitimate factor to take into account when we consider what legal obligations resulted from them. And that was the point at which I thought it was probably most sensible to look at the way in which some of those obligations in terms of protection and rights in employment have been implemented in domestic legislation. And so I was going to, if I may, my lords, my lady, take you to the Equality Act provisions very briefly.
Now, it's all very well to say in general terms we should factor in these considerations like recital 10,
Yes.
resolution. I mean, what does it actually mean, say, factoring? Are we, in terms of interpreting the statutes or
Yes.
regulations? We're
So-
not here concerned with the exercise of a discretion.
No. What it means in my submission is this: firstly, that there is a strong obligation on any court to interpret and apply UK equality legislation in a manner that's consistent with, firstly, the minimum requirements and protections in European law, but also that when one comes to look at how domestic legislation implementing those provisions is to be interpreted, that one has regard to those considerations.
You'll come back to this in more detail.
Yes.
Yeah, thank you.
Thank you. So if we can turn then to tab 14, and I wanted just to briefly consider the Equality Act provisions that underpin Mr. Ali's claims of direct discrimination. I have clearly seen and heard that you are familiar with the provisions of Section 13, which relates to direct discrimination. So I will take this fairly shortly. But you'll see that what is required is a treatment which is less favourable than the treatment of another. And we'll, of course, come on to consider what that other or who that other might be. And here you will see the offending subsection 13.6b, which talks about the, which is the exemption. It effectively says that where you otherwise have treatment which is less favourable treatment by B, if the protected characteristic involved is sex, then where B is a man, no account is to be taken of special treatment afforded to a woman in connection with pregnancy or childbirth. So
are we focusing in that provision, do you say, on the words in connection with?
yes,
I mean, those are the critical words.
yes. There are. I think there are two things that I say at the outset in relation to this provision. Firstly, that what you do not see in 13.6b is any reference to maternity or maternity leave, and that is.
I
Well,
don't
if
understand
you-
that, because I mean, pregnancy or childbirth are
Yes.
to do with maternity.
So the point being that it is a connection with the with those two things, and it is the strength or otherwise of that connection that falls to be considered.
So it doesn't in terms
It doesn't say maternity.
Maternity
No.
leave is out of bounds.
No, indeed. And there are other provisions where there is express reference to maternity, but not here. And the
Well, I think that's the most you can get at.
Well-
It doesn't expressly refer to maternity. It's
No.
shorthand
No.
for the three words: pregnancy or childbirth.
well,
I mean, what else is there? What else does maternity denote?
Maternity leave.
Maternity. Is that the point? It doesn't refer to maternity leave.
indeed.
Right.
And my lord, the short point is this: that it's an exemption. It's effectively it mirrors the derogation in, I think it's Article 2.3. So when one looks at it and one is seeking to apply it, one has to construe it narrowly and strictly. So we have to.
Hang on, that's correct.
Sorry.
So Article 2.3.
Yeah.
So the language in 13.6b is identical.
Well,
is it?
it's not identical, but it is implementing the special treatment provisions in the special treatment. It's seeking to implement the provisions for protecting workers who are women who are pregnant, have recently given birth, or are breastfeeding.
Right, so it's not that it mirrors.
No, it's not that it mirrors it, but
it's giving effect.
it's indeed.
It's giving effect. But the other point you made just now, that you were saying, because it's a derogation,
Yes.
it's interpreted narrowly.
Yes.
So it's implementing Article 2 of the Pregnant Workers.
Yes.
Right.
So there is the sort of interpretative point. There is the fact that it doesn't refer to maternity leave when it clearly could have done, and there is the point that we ought not to consider those provisions, in my submission, without considering the policy considerations that we have looked at in both the resolution but also in the various directives.
Right, and the policy considerations include, you mean, the equality of men and women at
Yes,
work.
yes. And if I can be forgiven for making a jury point at this stage, there are provisions, the approach taken to maternity in terms of its absence from 13.6b is in contrast with the express references that you will find, for example, in section 17 of the Equality Act. Now, I hope, but
Where is that?
oh, we don't have it. I'm sorry.
Unless it was in that additional clip.
Yeah, so there are, sorry, I said 17, it's perhaps section 18, which refers to discrimination in pregnancy and maternity. So clearly those matters were in the minds of the legislators for some respects, but those matters do not find their way into this exemption provision.
You said pregnancy or maternity is the protected character.
Yes,
Pregnancy or childbirth, practice or breastfeeding, is narrow. And you say that now, in connection with pregnancy obviously means before the birth,
yes,
and childbirth means 2 weeks after, and
Yes.
that's it. And then it becomes maternity rather than childbirth.
yes,
But I think you accepted the 13(6)(b) should be construed in conformity with Pregnancy Workers Directive 1992, which appears to me at least to draw the line at 14.
Well, I don't accept that it draws the line in any definitive sense at 14 weeks. I would accept that there is, and we've just looked at it, there is reference to 14 weeks, but it doesn't say maternity is 14 weeks and thereafter it's something else. So what I think the upshot of that is that it is a matter for those who are making the decisions in any particular case to decide whether the necessary connection with pregnancy or childbirth is somehow present in the case that is being addressed.
In the individual
In
case?
the individual case.
Right. So where we've got to, I think we've got to, is that a deliberate decision has been made in relation to the exemption 13, or derogation 13(6)(b),
Yes.
to limit it, as my lord pointed out, to limit it to a narrower sense than the definition of the protected characteristics.
Yes.
So that's a deliberate decision.
Yes.
In relation to childbirth, because I suppose maternity is simply a state of being a mother.
Yes. So it's not necessarily connected to childbirth.
No. Right.
And when we, sorry, and my lords, when we come on to look at the employment appeal tribunal judgment, you will see that there is an assumption that maternity necessarily means childbirth, as opposed to the state of being a mother. So that's a matter that perhaps I can deal with in due course. My lord, my lady, the next provision I was going to look at was the provision at section 23, which is in relation to the appropriate comparison for direct discrimination. My lords, my lady, I'm looking at the clock. I suspect that I'm going to be a little bit of time on this. I hope not too long. Are you content for me to start?
Oh yes, certainly.
I'm grateful. So, where we have arrived at is that there is a comparison necessary in order to substantiate a claim of direct discrimination. And that comparison requires, as we see at 23 at subsection 1, that there must be no material difference between the circumstances relating to each case. And my lord, you asked whether there has been consideration of what material means for these purposes.
Yes.
And you've in fact been taken to some recent or more recent formulations of what that might look like. But the sort of key statements of principle, and I've canvassed this very briefly with my learned friend, Mr. Burns, are to be found in the case of Shamoon and Chief Constable of the Royal Ulster Constabulary, which, my lords, I think you may have had handed up to you. It's a yes, it is a very long case, and I don't propose, unless there is any particular appetite for it, to take you through it. What I submit, and I think I leave it to my friend to advise you if he disagrees, is that in this case, which has facts which I don't think are necessary to rehearse. The House of Lords were considering who the appropriate comparator was in a sex discrimination case. And the conclusion in terms of who a comparator might be was that the comparator required in the exercise that Section 13 necessitates is somebody who is in the same position in all material respects as the complainant, was the victim, save only that he or she is not a member of the protected class. And you'll see in the holding in paragraph 2, that means that the comparator can be a hypothetical comparator. It doesn't have to be an actual comparator. If I can just point you firstly, my lords, my lady, to page 339 at paragraph 4, which just notes that the statutory definition calls for a comparison between the way, in this case, the employer treated the claimant woman and the way he would have treated or did treat a man. Stands to reason that in making this comparison, with a view to deciding whether a woman who was dismissed received less favourable treatment than a man, it is necessary to compare like with like. The situations being compared must be such that, gender apart, the situation of the man and the woman are in all material respects the same.
Yes.
And then you see over the page just confirmation that that is the position, whether or not the comparator is an actual comparator or a hypothetical one. There are other passages which refer, that make, I think it's fair to say, a similar point. And of course, you've heard most recently from Mr. Leach, he's taken you to some authorities on the point, albeit that he drew rather different propositions for them than I might. But there were some things, and I'm thinking in particular of the cases of Lockwood, which was behind, just bear with me, it's behind tab 28, but I'm not entirely sure. 22, thank you.
Was it 22 in one?
Behind tab 22. That was an age discrimination case, but you will first of all note in the holding confirmation of the received position as to the comparison required. So a person who was in the same position in all respects, say that he or she was not a member of the protected class, and then the passages where that is developed. I will take you firstly through to.
This is a direct discrimination.
This is a direct discrimination case, so it's perhaps more on point for my purposes than it was for Mr. Leach's.
What's happening here is that the comparison that's being made is for the purposes of establishing less favourable treatment.
Yes. So pausing there, that's precisely the comparison that you would be required to undertake in a direct sex discrimination case. The only issue is the reason for that treatment is different because it's a different protected characteristic.
Yes.
And if I invite your attention to page 261, and I think this is the judgment of Lord Justice Reimer, paragraph 33. He makes the point I've just made, which is that the language is similar in relation to sex and race, and it similarly requires a comparison between treatment received by the claimant and that which was or would have been received by an actual or hypothetical comparator, and the relevant circumstances must be the same, not materially different, and then cites the Shamoon, which we very, very briefly looked at. And if I can take you over the page to paragraph 34, I think this is a passage which is helpful. In a race discrimination case, it means that if a black complainant is alleging discrimination at work on the grounds of his race, the comparator will usually be a white person who is otherwise in the same or a not material different position. And it's obvious that once such a comparator has been identified, the tribunal cannot hold the relevant circumstances of the two cases are different on the ground that the comparator is white and the complainant is black. The whole purpose of the comparison is as an aid to seeing whether or not the way in which the comparator was or would have been treated in the relevant circumstances supports the claimant's allegations.
But isn't this really a reflection we saw Lady Hale saying,
Yes.
which was say, what you've got to do is you've got to identify what it is
Yes.
that
Yes.
is common between them and whether that is the material commonality.
Yes, you've got to
That's all we have to do.
precisely that. And if I can, I think it was the Lockwood case, sorry, not the Lockwood case, the Secretary of State for Justice case behind tab 31. And if we I think we would take it to,
case.
yes, it's the Cole
It's
case.
the Cole.
Yes.
Yes, it's paragraph 32.
Yes, it's paragraph 32. So,
That all makes sense.
yes. So one has to, and this again is relevant to what I say went wrong in the Employment Appeal Tribunal analysis. One has to strip away those circumstances which are part and parcel of the protected characteristic. And so to say, well, your comparator has to, as she did, your comparator has to have been pregnant, given birth, and be on maternity leave. That is, those circumstances are not material circumstances for the purposes of the comparison that needs to be undertaken in Mr. Ali's case. Because Mr. Ali is saying, I wanted to take time off to care for my child and to receive the same level of pay as a woman would receive if she were on maternity leave. Now, what's relevant is not the kind of leave that she's on, it's their circumstances. And so we say that you can't factor in maternity or motherhood or childbirth into the comparison because to do so builds in the protected characteristic that you're looking at and trying to evaluate as to whether or not that's the cause of treatment. So what we say about the proper comparison on the facts of Mr. Ali's case is that the comparator is somebody who is a woman, rather, not somebody, is a woman who has decided that she wishes to take leave to care for her child. That's the comparison. And it's about what would the treatment of her be. We looked, I think, at the passages that I wanted to direct your attention to, which are at paragraph 32, F in particular. So the way that we have. So this is still in Cole at paragraph F. And perhaps also because it may again feature in terms of the reasoning of the Employment Appeal Tribunal at paragraph 30. It cannot be a requirement of direct discrimination that all the people who share a particular protected characteristic must suffer the less favourable treatment complained of. It's not.
That's paragraph 30.
That's paragraph 30.
I don't have it. Which letter is it next to?
It's next to B. So it's the beginning of paragraph 30, starting furthermore.
Oh, I see.
Yeah.
That's the beginning.
But ESOP was a
Indirect, exactly. And of course, if I
I'm not quite sure whether why are you relying upon that sentence in paragraph 30? It's not to do. That's not relevant to our issue.
no,
Is it?
it's not directly relevant, but it is. The point I wanted to make is this, that my learned friend in taking you to this case said, if you're saying that one can't compare men with women because men and women are different, that makes a nonsense of the legislation. That was his submission in relation to indirect discrimination. Well, if one is saying, as the Employment Appeal Tribunal essentially said in this case, you can't compare men with women because men and women are different. Women get pregnant, have children, men don't. Then it makes a nonsense of the direct sex discrimination provisions.
Is that a convenient moment?
Yes, I'm grateful.
Thank you very much.
Thank you, my lord.
Slide 5.